What happens when an AI model draws inspiration from a copyrighted article or photograph to generate something new? And what if that creation becomes part of a commercial product? The line between inspiration, transformation, and copyright infringement is becoming increasingly blurry. And now Europe is being called to draw that line once and for all. The Court of Justice of the European Union has received its first ever case dealing with copyright in the context of generative AI. It's a battle that has already begun in the United States, where fair use has triggered a wave of lawsuits, headlines, and controversy. But will Europe follow America's path or take a harder stance? Welcome back to Diritto al Digitale, the podcast where we explore the intersection between law and innovation. I'm Giulio Coraggio, a technology and data lawyer at the global law firm DLA Piper. And today we are diving into a legal issue that could redefine the development of generative AI across the European Union. The first case before the European Court of Justice concerning copyright protection in the age of artificial intelligence. We'll also look at how the United States is approaching the same issue through the lens of fair use and what this all means for developers, creators, and AI companies. The story begins in Hungary with an eccentric article published by the company Like Company on a website whose name is really complex to pronounce, so I'm sorry, but I will not do it. The piece featured unusual claims about the Hungarian pop star named Kocso, including his alleged plan to release dolphins into Lake Balaton, along other details gathered from public sources like newspapers and social media. Later, a user asked Google Gemini's chatbot to summarize information about Kocso in Hungarian. According to Like Company, Gemini's response echoed the same phrases found in the original article without attribution and without any license to use the copyrighted content. This led to a lawsuit in Hungary, and now the Hungarian Supreme Court has referred the case to the European Court of Justice. At stake, whether the generation of text by an AI model can amount to copyright infringement, and even when it occurs in response to a single user prompt. The court has been asked to answer three pivotal questions. Number one, does AI-generated content that reproduces protected elements qualify as a communication to the public? Number two, can such output be considered unauthorized reproduction even if not published separately? Number three, and could this fall under any exceptions or limitations under EU law? These questions are not just technical, they are highly political. The European Court of Justice ruling will set the rules for large language models like ChatGPT, Gemini, and Claude across the entire EU market. Meanwhile, across the Atlantic, courts in the United States have already weighed in similar cases during the last weeks, with very different outcomes. In two recent rulings, US judges accepted that companies like Meta could invoke the fair use exceptions to justify using copyrighted material for AI training. One judge summed it up like this: no previous case answers the question whether Meta's copying was fair use. The question must be answered by flexibly applying the fair use factors. That's the key difference. The fair use system in the United States is flexible, based on four broad factors. Number one, the transformative purpose of the use. Number two, the nature of the original work. Number three, the amount of content copied. And number 4, the market effect of the use. American judges have recognized that even large-scale automated AI training can be considered transformative and possibly fair use if it supports technological progress. However, they've also made it clear if the training harms the original market, copyright holders may still win. So the outcome depends on how the facts play out case by case. The legal divide reveals two competing visions for how to regulate AI and copyright. On one side, the EU enforces strict copyright protection with a closed list of exceptions. That means generative AI developers might have to license every single piece of content they use to train their models, an enormous challenge. On the other side, the US provides more flexibility, but also more legal uncertainty. Every case becomes a battle with costly litigation and no clear precedents. And now that the AI Act has been passed in the European Union, more questions arise. How will developers be required to document their training datasets? Will strict data governance standards apply? And who bears the responsibility for copyright compliance? The AI provider or the end user? These issues will soon come to the forefront. We are at a turning point. The European Court of Justice ruling could shape the entire future of artificial intelligence development in Europe. And the line between technological innovation and copyright violation has never been thinner. How should we regulate the use of copyrighted materials in AI training? Should Europe embrace a stricter model or take a more flexible American approach? I'd love to hear your views. Write to me at giulio.coraggio@thelapiper.com. If you found this episode insightful, subscribe to Diritto al Digitale and activate the bell to stay updated on future releases. And if you like this episode, please give us a 5-star review on Apple Podcast or Spotify. I'm Giulio Coraggio, this is the podcast Diritto al Digitale. Arrivederci!